Mr. Victor Okafor had a successful banking career that saw him work for several banks both in Nigeria and in the United Kingdom. He had his university education in the United Kingdom and worked with one of the big banks in the United Kingdom before returning to Nigeria. He rose to the position of Executive Director in First Bank of Nigeria plc before his appointment as the Managing Director of Mercury Continental Bank. Mr. Okafor arrived at the head of Mercury Continental Bank like a headline. He had the look and the rhythm of success: tidy suits, a short, practiced laugh, and ease in front of investors that made nervous capital look like an afterthought. Okafor's time at First Bank gave him a deep acquaintance with large corporate structures and the levers of financial presentation. Mercury Continental was, when he joined, a credible mid-tier player, a bank with good regional footings, a cluster of corporate clients, and a management team that wanted to break out of the comfortable middle. Okafor gave that appetite a voice. He talked to shareholders about market share and scale. He talked to bond investors about diversification. He talked to partners about banking without borders, meaning not literal geographic borders alone, but the removal of internal constraints that prevented the bank from moving fast. The bank's market story was seductive. Branches multiplied, glossy ads hit billboards and television, and Mercury's share price rose in a way that made even hardened market watchers raise an eyebrow. Okafor's mastery of investor relations and capital markets meant that taking on public debt and raising equity was comparatively straightforward. He had shown a talent for building narratives that markets accepted. It was a talent that, in an era of cheap capital and a national premium on growth, seemed like genius. But growth, especially in banking, is a discipline. You can grow your balance sheet without building the muscle to sustain it. You can add assets without adding the controls that make assets meaningful. And that is where the lines between brilliance and recklessness begin to blur. As Mercury's assets swelled, the bank's internal rhythms changed. The urgency that had won praise for its speed began to cast shadows over internal deliberation. The institution began to prize market signals, rising share price, press visibility, and swelling assets, over the slow, granular work of convincing its books to match reality. Okafor's strategy for Mercury was simple in outline and aggressive in execution. Expand the balance sheet rapidly, capture market share, and use new assets to justify further capital raises. He pursued corporate lending, acquisition finance, and targeted wholesale funding to obtain cheap sources of deposit equivalents. The bank's management presentations emphasized scale, larger loan books, sophisticated client services, the ability to underwrite bigger deals than the competitors. The operational ingredients were familiar: relentless sales pressure on relationship managers, incentives tied to booked volumes, and a credit culture that rewarded growth. But in execution, the assembly of those ingredients raised questions. Loan approvals were sometimes permissive. Oversight committees existed, but they frequently operated in an era when groupthink meant speed of approval and a reluctance to obstruct top management. The best-case scenario is that management and the board had faith in the deals and moved decisively. The darker possibility is that the push for size systematically thinned the scrutiny that should have accompanied the expansion. Two structural features made the expansion possible. First, Mercury's capital structure allowed it to leverage attractive ready access to short-term institutional funding and to raise equity at favorable valuations during the boom years. Second, corporate clients, often complex, multi-company groups with cross-ownership and opaque beneficial ownership, sought larger credit facilities as they pursued acquisitions and asset plays. Mercury was happy to oblige. The products were not exotic. They were, rather, large and sometimes poorly documented. Loans to companies with tight connections to directors and senior management began to rise as a share of the portfolio. At the same time, the bank created and relied on complex webs of special-purpose vehicles, SPVs, and holding companies, captured in the bank's books as corporate borrowers or as collaterals, that obscured the economic relationships underpinning the credits. Those two features came together in a way that looked like success from the outside. A bank that is growing aggressively and funding seemingly profitable companies presents well to shareholders. But when the assets are not delivering cash flows and the collateral is either overvalued or illiquid, a comparatively small downturn can produce outsized capital stress. The decisions that look like tactical responses to fast-moving opportunities were, in aggregate, creating a balance sheet architecture that would not withstand a systemic shock. It is tempting to think of bank fraud as a single spectacular heist. The truth, borne out in many investigations of failed banks, is that the damaging choices usually appear as ordinary lending activities: loans approved, collateral taken, legal documents signed. Mercury's story is that kind of story. The bank's book, as the prosecutor's later case described it, contained numerous large facilities to entities that were connected through shareholdings, common directors, family ties, or business arrangements to people close to the bank's senior management. Those relationships were not, on their own, illegal. Banks lend to director circles in many jurisdictions when legal safeguards and disclosure rules are respected. The problem occurs when disclosures are incomplete, when approvals are not independent, and when collateral is illusory. The prosecution's case, to be clear, alleged that Mercury's credit approvals routinely failed to meet even the bank's published standards. The raw pattern that regulators and later prosecutors pointed to included facility offer letters issued or signed without full credit committee approval or without proper documentation. Collateral accepted that, on closer examination, was worthless, non-existent, or pledges over assets the borrowers did not control. Loans routed through SPVs and holding companies that made the beneficial ownership and the ultimate flow of funds opaque. Retrospective board minutes and memos produced after transactions were effectively done to create the appearance of governance and compliance. The bank's finance teams often recorded the loans as performing. Internally, profit funnels often recognized fees or off-balance sheet gains even while cash flows were strained. The net effect was that profitability looked better than it was, and capital adequacy ratios were artificially bolstered by asset valuations and the continued recognition of income that litigation and collection later belied. It is critical to emphasize the difference between allegation and judicial finding. The Anti-Corruption Agency alleged in its indictment that these and other practices were part of a criminal scheme to divert funds. The court records later contained detailed evidence, internal emails, memos, testimony from insiders, that tended to support a picture of poor circulation of information, superficial oversight, and an institutional bias toward approval. Where judicial findings exist in the public record, I note them later in this narrative. Where points are part of prosecution allegations or media reporting, I mark them as such. A bank's board is its firewall. At Mercury, on paper, the board installed committees: an audit committee, a risk committee, a credit committee. The composition satisfied regulators and satisfied shareholders who wanted experienced names to reassure them. In practice, however, the dynamic was different. As Mercury expanded, the board came under pressure to signal support for corporate strategy, not to create roadblocks. Directors were flattered by the success story. They heard from management about market opportunities that required nimble execution. Punchy quarterly results and confident forecasts created a social momentum that made dissent difficult. The management's tone was unmistakable. The market demanded pace. The board's culture, which should have been a skeptical second voice, often became a supportive chorus. That is not necessarily criminal. It is a governance failure, one that created the conditions for risk to accumulate. A specific governance hazard was the delegation of authority. Where boards delegate, they must create clear bounds. At Mercury, many loan approvals were effectively pushed down the organization but approved ex post by management with board notes prepared after the fact. In some cases, official minutes were drafted to reflect what had already been done. The later court record shows examples of memoranda dated after the deal had closed, with signatures and stamps supplied in a way that made the files look completed before regulatory scrutiny began. Again, some of this the prosecution framed as evidence of deliberate concealment. The defense argued that paperwork sometimes lagged decisions in a high-pressure environment and that management acted in the bank's interest. Internal audit and risk functions were also understaffed relative to the growth they had to monitor. Risk systems, too, were slower to adapt than the commercial appetite. That mismatch, where controls lagged the business, meant that early warnings, even when they appeared, did not trigger corrective action. The Central Bank Nigeria, CBN's later assessment called this a systemic issue, an organization optimized for growth, not for stability. Mercury's rise occurred in a period when global liquidity, rising commodity prices for certain sectors, and strong domestic economic growth made many loans appear less risky. The boom environment muted concerns about leverage and asset quality. It also made investors and shareholders more tolerant of aggressive growth. But banks that have grown quickly are exposed when conditions change. Two external shocks were most relevant. First was the global liquidity and confidence shock of 2008, which rerouted capital flows and tightened access to wholesale funding. Second, domestic economic fluctuations, including a downturn in certain sectors that had been heavy borrowers, eroded the performance of portions of Mercury's loan book. In a benign world, illiquid assets find buyers. In a stressed world, the same assets are discounted sharply. The problem for Mercury was that a number of its large loans were not producing steady cash flows and were not readily marketable. Capital ratios, which had been buoyed by asset valuations and recognition of anticipated earnings, began to look fragile when measured against stricter regulatory eyes. The CBN's intervention did not arrive ex nihilo. Regulatory supervisors kept an eye on the system and, as part of a general tightening of supervision in the aftermath of global stress and a domestic cleanup agenda, initiated special examinations of several banks. Mercury was one of the institutions singled out for an in-depth review. Special examinations are forensic. They look beyond headline numbers to the quality of assets, the reality of collateral, and the integrity of governance and disclosures. The central bank's examiners reviewed loan files, tested collateral, and traced the flow of funds. Their report, summarized publicly by the regulator and later relied upon by the prosecution, identified several features that were deeply concerning. Large, concentrated exposures to related entities and to companies with complex ownership chains. Insufficient provisioning for loans that displayed signs of impairment. Weaknesses in documentation, including missing or inadequate security documentation. The use of SPVs and other vehicles that made ownership and the in-use of funds opaque. Indicators of potential misclassification of non-performing loans as performing. The regulator, acting on the seriousness of the findings, took decisive steps. Recognizing that the bank's capital base was inadequate to absorb the losses implied by asset quality, the central bank placed Mercury under statutory intervention. That intervention took forms designed to stabilize depositors and preserve systemic confidence. Suspension of certain management powers, appointment of an interim management team, and in some cases, the removal of senior executives from day-to-day control while the bank was recapitalized or restructured. The central bank's action was, by design, both prudential and public. It was intended to stop harm spreading through the banking system and to signal that regulators would not permit systemic risk to fester. For Mercury, the intervention meant a dramatic reputational blow. Where the bank had once been a success story, it was now a headline about regulatory failure. Regulatory findings do not automatically become criminal cases, but when regulators see potential misfeasance, transactions that look like deliberate attempts to mislead, conceal, or divert, they often refer matters to anti-corruption agencies for further probe. In Mercury's case, the regulator's special examination provided a paper trail that the National Anti-Graft Agency found sufficiently concerning to open a criminal investigation. It is necessary to spell out a few distinctions. Regulators pursue capital adequacy, liquidity, governance, and market stability. An anti-corruption agency pursues criminal violations, fraud, theft, conspiracy, and similar offenses. The line between regulatory failure and criminality is not always bright. It is the prosecutor's job to show a criminal intent and the court's job to determine whether the evidence supports a criminal conviction beyond reasonable doubt. The Economic and Financial Crimes Commission, EFCC, on referral from the central bank and after its own inquiries, charged Victor Okafor, his close associates, and company entities with a raft of offenses. The indictment alleged, in simplified terms, that certain large sums were obtained by false pretense, that loans were granted and recorded in ways intended to conceal their true nature, and that funds were diverted to entities controlled by or associated with persons close to the bank's management. The indictment itemized dozens of transactions and quantified the sums that, investigators alleged, were misappropriated. The agency's public statement framed the case as a landmark enforcement action, one designed to demonstrate that bank executives were not beyond the reach of the criminal law if they abused their positions. The agency's lawyers said they had voluminous documentary evidence, facility letters, internal emails, board minutes, payment instructions, and witness testimony. The defense, predictably, insisted the transactions were legitimate banking activities and that losses arose from economic conditions rather than criminal intent. The indictment was comprehensive. It named the bank's chief executive, his spouse, the chief financial officer, and several corporate entities that the prosecution said were used to effect transactions. The counts range from conspiracy to commit felony, to stealing, to obtaining money by false pretense. The headline sum alleged to have been misappropriated or improperly obtained ran into the tens of billions of naira. In the indictment as presented publicly, the prosecution set out a sum that underpinned the case it would prosecute. The charges included detailed allegations about facilities, the identity of the borrower or corporate entity, the dates of approvals, the amounts disbursed, the stated collateral, and the subsequent performance, or lack thereof, of the loan. The agency's charge sheet also identified some of the SPVs and holding companies through which the transactions moved. The prosecution alleged misuse involving entities such as Argo Holdings, Northbridge Energy Limited, and Meridian Trade Limited. It is necessary to emphasize that an indictment is an accusation, not a finding of guilt. The law requires a criminal prosecution to prove its case in open court. Yet indictments are usually framed after careful investigation. They reflect the charging agency's judgment that sufficient evidence exists to suspect criminal culpability and to push the case to trial. The pretrial stage in big bank prosecutions is often lengthy. The accused challenge the sufficiency of the charges. They argue procedural points, claim abuses in the investigative process, and seek bail or discharge. In Mercury's matter, the initial hearings included vigorous courtroom disputes about admissibility of evidence, the procedure used for certain searches and seizures, and the conditions for bail. Victor Okafor's defense team, a cadre of senior lawyers and regulatory specialists, argued that the bank's collapse was a systemic failure and that responsibility could not be pinned solely on the CEO, They filed motions challenging the consistency of documents, the timing of some alleged payments, and the legal sufficiency of certain counts. Some motions sought a stay of proceedings on jurisdictional grounds. Other motions sought disclosure of the regulator's internal memos. Meanwhile, the anti-corruption agency faced the public pressure of prosecuting a high-profile banker. Media coverage was intense. The trial became a proxy terrain for broader debates about governance, political economy, and the dangers of concentrated power in banking. For the accused, public perception mattered. For the state, achieving a conviction would verify the regulatory cleanup. The pre-trial phase stretched. Rules of procedure required disclosure and exchange. Witnesses were identified. Some witnesses requested immunity or plea bargains in exchange for cooperation. The complexity of corporate structures, cross-border banking connections, and the number of implicated transactions meant that the trial, once it started, would not be brief. The defense attacked the forensic methodology, questioning assumptions about the identity of beneficial ownership and arguing that some transfers were legitimate treasury operations. They also pointed to the messy nature of business groups, where cash pools, subrogation, and intra-group loans are common, and argued the forensic lens mischaracterized normal corporate finance arrangements as illicit. A trial of this scope depends on witnesses with first-hand knowledge. Some of the most damning testimony for the prosecution came from bank insiders who described pressure from above and a culture that discouraged no. These witnesses were not uniformly reliable. Their motives were scrutinized by the defense, which emphasized any incentives they had to shift blame. The prosecution's cooperating witnesses included former senior managers who admitted to participating in misstated files or in backdated memoranda, and who testified that they had acted under the direction, or at the least with the blessing, of top executives. They described approvals that had not followed the formal flowchart the bank's governance required. One cooperating witness described, under oath, a meeting in which certain loans were effectively green-lighted by executive fiat and then processed administratively to appear regular. The defense cross-examined these witnesses vigorously, pointing out inconsistencies and suggesting alternative motives, personal grievances, fear of exposure, or incentives offered by prosecutors. The judges would have to weigh the credibility of these witnesses. Such assessments are central to fraud trials, where documentary evidence rarely tells the whole story and witness testimony fills the narrative gaps. The prosecution rested heavily on documentary evidence, facility letters, board memos, collateral documentation, client communications, and internal audit reports. In many of the contested transactions, the prosecution pointed to gaps, missing collateral files, incomplete facility offers, and internal notes that contradicted the later official record. In some instances, the prosecution presented retrospective memos as evidence of attempts to create a compliant paper trail after the fact. The defense explained these events as routine administrative lag, cases where documentation was finalized after an urgent business need had been met. The court's job was to assess whether failures to produce contemporaneous documentation were the product of sloppiness or were reflective of an attempt to conceal unlawful diversion. Forensic evidence sometimes established that certain documents had been created on dates that postdated the transfers. Where documents memorialized approvals that purportedly occurred prior to disbursement but were dated after, prosecutors argued the documents were crafted to masquerade as contemporaneous approvals. The defense argued that in a fast-moving commercial environment, it was not uncommon to memorialize decisions after execution, especially when management had to respond to client liquidity emergencies. At the heart of the legal contest was a difficult moral and legal inquiry. When does poor judgment or risky commercial banking cross into criminality? The prosecution alleged that management had exploited the bank's procedures to divert funds. The defense argued that management had pursued legitimate business objectives that failed because of macro events and poor economic performance. The law requires prosecutors to prove dishonest intent or actions that amounted to criminal conversion, fraudulent misrepresentation, or conspiratorial behavior. The defense sought to show the absence of mens rea, that decisions were business errors, not criminal choices. In many places, the trial hinged on narrow factual disputes: who had final sign-off on certain documents, who had the authority to reallocate collateral, and whether certain payments were indeed repayments or disguises for transfers to insiders. After years of hearings, testimony, and documentary evidence, the court delivered its judgment. The judge, sitting after careful consideration of the evidence, found the defendant guilty of key counts of conspiracy and stealing. The court's written reasons summarized the pattern of conduct it deemed proved beyond reasonable doubt: management-driven approvals that bypassed proper scrutiny, loans made and recorded without adequate collateral that were effectively channeled to entities controlled by insiders, and documentation practices that suggested deliberate attempts to mask the true nature of transactions. The judgment was precise about the legal basis for conviction. The court emphasized that while business risk is not criminality, the deliberate manipulation of a bank's books and the diversion of funds to connected parties in the manner found by the court constituted criminal theft and conspiracy. The judge noted the reckless manner in which funds were handled and stated that senior management cannot claim the mantle of corporate decision-making when their acts amount to the willful misapplication of depositors' funds. Sentencing followed. The court imposed a custodial sentence on the defendant, initially a term that the judgment described in specific years, and ordered a restitution direction, in order that the defendant refund a significant sum to the bank or to a liquidator or administrative receiver tasked with recovering the bank's assets. The court's restitution order was an attempt to remediate the financial damage, recognizing that criminal sentences alone do not compensate harmed depositors or taxpayers who absorb the bank's failure costs. Co-defendants received mixed outcomes. Some were convicted and sentenced, others were acquitted. The court's outcomes reflected its assessment of individual culpability, the presence or absence of proof for each charged person and each charged count. Criminal trials of this scale almost inevitably proceed through appeals. The defendant's legal team lodged appeals challenging both conviction and sentence on several grounds: alleged misdirections in law, misapprehension of evidence, and procedural irregularities. Appellate courts review both factual findings and legal conclusions. In this case, an appeal court reviewed the trial record and modified the original sentence, reducing the custodial term while leaving the conviction intact for certain counts. Appellate judgments are technical and meticulous. They assess whether the trial judge correctly applied the law and whether the weight given to certain evidence was reasonable. In sometimes complex corporate crime cases, appeals can succeed on narrow grounds: procedural missteps, misapplication of sentencing principles, or legal errors. Appeals rarely erase the basic facts found at trial, but they can produce mitigation of sentence and clarifications of legal principles that govern future prosecutions. In the Mercury case, the appellate judgment affirmed much of the trial court's core reasoning while moderating the penalty. The restitution order remained in place, and subsequent civil and insolvency processes continued their own work to recover value and compensate creditors. The criminal process addresses culpability. The financial consequences are handled in parallel by insolvency, receivership, and regulatory mechanisms designed to protect depositors and preserve systemic stability. Mercury's legal resurrection was not possible. The bank had suffered systemically weakened capital, and the intervention had already placed it under the administration of a receiver tasked with stabilizing the institution, recovering assets, and protecting depositors. The restitution order was part of the legal mosaic. Criminal courts ordered repayment. insolvency processes sought to reconcile creditor claims and to distribute recoveries. In many cases, recovering the sums ordered in criminal restitution is difficult. Assets may be dissipated, foreign jurisdictions may be involved, and complex corporate structures can delay or dilute recovery. Nonetheless, the criminal orders signaled a moral and legal recognition of the scale of the harm. Systemically, the events at Mercury and other contemporaneous bank failures prompted regulatory reforms. Supervisors demanded higher capital buffers, sharper conflict of interest rules, improved disclosure on related party exposures, and more robust internal audit functions. The episode pushed markets to reassess how they valued growth stories and to re-emphasize quality of governance as a determinant of long-term stability. For Victor Okafor personally, the conviction and custodial sentence were a dramatic reversal of fortunes. The executive, whose public persona had been linked to pride in management and corporate success, became the subject of a cautionary tale. Public debates about the accountability of senior bank executives intensified. Were heads of banks being held sufficiently accountable? Did the punishments fit the harm? Could the legal system both deter misconduct and encourage honest entrepreneurship? The court's verdict resonated as a deterrent message. That message, however, does not erase the human complexities. Many of the other employees at Mercury, relationship officers, tellers, back-office staff, went on with their lives, affected by layoffs and reputational spillover. The banking industry, which thrives on trust, had to rebuild the public's faith. What are the lessons from this long saga? There are many, and their application matters in banks, corporations, and regulators. Governance must be substantive, not cosmetic. Independent directors must have the information and incentives to dissent when needed. Boards must be structured to resist the seductions of growth narratives that obscure risk. Internal controls and audit functions must scale with growth. Organizations that thin their controls in the face of expansion create fragility. Transparency in ownership and in lending relationships is essential. SPVs and holding structures are not inherently malicious, but they require higher transparency and stricter scrutiny. Supervisors must act decisively when lapses are identified. The central bank's intervention, though politically contentious, was intended to prevent wider systemic harm. Prosecutors must make careful distinctions between business error and criminality. Criminal enforcement should be used when evidence shows mens rea and deliberate diversion. Otherwise, regulatory and civil remedies may be more appropriate. The Mercury Continental Bank story and the personal trajectory of Victor Okafor are cautionary tales about the interplay between ambition and control. They remind us that leadership invites both admiration and scrutiny, that the qualities enabling rapid expansion are not always the same qualities needed to maintain institutional integrity, and that public trust in financial institutions is fragile. This narrative is also a study in institutions, how regulators, prosecutors, courts, and insolvency mechanisms interact when things go wrong. The sequence from regulatory special examination to criminal indictment to trial and sentence illustrates the multiple pathways through which societies hold powerful actors to account.